right, guys. Thank you so much for being here. This is a bonus to Barry Cohen's annual OWI conference. It's sort of fortuitous the way it worked out. I had an opportunity to discuss with Barry the possibility that he might start to offer, I was hoping at some time in the future, because he puts on such a great conference, that he'd do something not just OWI related, but a little bit more broad. And so I think he's got that on his mind. But as it turns out, this is where this sort of presentation would fit. This presentation is sort of the basics of criminal appeals, the basics of appellate process. And I know that while we do a lot of tangential stuff with Barry's normal in-person live conference, he really does try to keep it OWI focused. So this is a little bit out of the ordinary. We expect it to go just about an hour. And certainly if there are those of you watching it on demand afterward, I am available for questions. You can email me at anthony@criminallawyers.esq. That's ANTHONY at criminallawyers.esq. So, as you can tell, I am recording this from my home office, and we are going to be offering it on demand. We've got a couple of attorneys joining us virtually right now as the Board of Bar Examiners says, hey, we need to have a couple of people in attendance just to make sure that there is a check on the speaker and that they're not offering total nonsense and sitting in front of their camera saying, hey, I earned double credits just for talking in front of my camera. So that said, we do have a couple of lawyers in attendance, and if there's any questions, they will just speak up during the course of the recording. But if anybody watching this on demand has further questions, just feel free to email me. So, as I said, in my home office, it's a little bit of a different environment. I've got the American flag behind me, basically because our role is constitutionally mandated. The right to counsel is in our Constitution. Also, the pirate flag, simply in keeping with Dean Strang's admonition that even though we are written into the Constitution, the system needs challenging. So I understand it's a little bit of an odd background given that I'm coming from the home office, but that is in fact where we're coming from, and I think it's applicable. So on to the topic of the CLE, appeals basics. So you fought hard and you've lost, and there was probably some pretrial litigation, at least in terms of motions in limine or rulings to let in evidence or failure to suppress evidence. And having lost, you're sure the judge's pretrial rulings or the prosecutor's presentation make a conviction reversible. Or maybe even there wasn't a trial and your client had to enter a plea because a judge simply didn't suppress evidence and that was dispositive. So this is an outline of the appellate path in Wisconsin, with some outline of federal courts and some discussion of appealable issues. But the primary goal throughout is to outline the appellate process pretty thoroughly so that you can be informed and knowledgeable about it, and you can broadly convey it to your clients. So that's the level of detail that we're going for. So you can understand it more thoroughly, and you can convey it to your clients in a broad way that you can translate the legalese for them. A secondary goal, though, is to discuss some of the nuances of review and decisions. Every year at Barry's conference, Sarah Schmeiser and I have done the case law review, where we go over all of the cases, whether it's by the U.S. Supreme Court, the Wisconsin Supreme Court, and more often the Wisconsin Court of Appeals. And we always talk about per curiam cases or authored cases. And so we'll dive just a little bit more into what's behind some of that. So when you're doing your own motion practice, you will be able to, for instance, ascertain what is easily citable and what isn't citable or what needs to be cited with a little warning and a footnote. So, on that note, in an introductory note, I would say it's really important to parallel cite your authorities. And by parallel cite, I don't mean it like we learned it in law school, where it means cite to the WIS second and also the Northwest Reporter. I mean that you should cite to both Wisconsin authorities and federal authorities. So let me just show an example of that. I'm going to share a window. Okay. So this is 80930. That's the broad outline that we'll be going through here. But now what should be popping up here is State versus Roddy Daniel. That was a Wisconsin Supreme Court case that I had. And it just happens to include a really good sort of parallel site that I'm talking about. Looking down here at
I don't see anything if you're sharing your screen, I don't see anything.
oh, well, thank you for letting me know. How
That
about now?
e it's yes, now I see it. Thank you.
Awesome. No, thank you. I appreciate that. It would have been weird if I kept talking and there wasn't a screen there. So this shows what I mean when I'm talking about parallel citations. You can see that um, the justice in this case cited the Wisconsin statute, and then she also cited the U.S. Supreme Court case, Dusky versus United States, which was the seminal case back in 1960, which said, hey, a defendant needs to be competent in order to be tried. And it said what the test for competency was is that they have a present ability to consult with their lawyer and a reasonable degree of rational understanding of the proceedings against them. Now, Wisconsin adopted that long before State versus Burge, but she cited State versus Burge for the same precedent. The defendant is incompetent if he or she lacks the capacity to understand the nature and object of proceedings, to consult with counsel, or to assist in preparation of his or her defense. So you can see that those are largely similar and also a little bit different. Of course, when you're in a Wisconsin court, you're going to be arguing about the Wisconsin statutes and the Wisconsin case law. But I think that it can also be beneficial in terms of just adding a little bit of gravitas to your argument. And certainly for the purposes of preserving it for later appeal, if God forbid you lose your case and you lose at the Court of Appeals and the Supreme Court, and either you or some other attorney needs to appeal to the federal courts, whether it's the U.S. Supreme Court, the district court, or the circuit courts. So, another introductory note is that unfortunately, most appeals are unsuccessful, and I don't want to be discouraging about that, but it's absolutely true. I will go ahead and share my screen again here. All of these links will be shared in the program materials. And this is one that you would have seen at Barry's conference in person. It's the Court of Appeals annual report for 2023. They put this report out annually. They haven't done the one for 2024 yet. I believe it comes out in June or July. So fairly simply, you can look through this and see what number of appeals were filed, whether they were appeals as of right or if they're interlocutory appeals. And if you scroll down far enough, you'll be able to see what percentage of them was affirmed and what percent was reversed. And so in criminal cases here, overall, 83% of trial court decisions are affirmed. Now, you might think, hey, that's great. I've got a 17% shot at winning. I will remind you that the state gets to appeal. And in many I would say in a fairly large percent of that 17%, it's going to be the state that was appealing the decision of the court. So scrolling back up just a little bit, we can see that in 2023, there were 112 leaves to appeal filed. So that's the first thing we're going to be talking about is something you all might run into in your practice, which is when the court makes such an awful decision that you simply can't go forward with litigation and you've got to get an appeal done. You've got to get the Court of Appeals to hear it before you even go forward because that's how bad the circuit court screwed up. The point I'll make while I'm on this screen yet is that the Court of Appeals doesn't even take 10% of those when asked. And in previous years, I believe they've taken even fewer. So interlocutory appeals are very unfavored, very disfavored. Uh, the standard for what should be the standard, what the announced criteria is for the Court of Appeals in determining whether or not it's going to accept an interlocutory appeal or a discretionary appeal is number one, that it would materially advance the termination of litigation or clarify further proceedings in the litigation. Number two, that it will protect the petitioner from substantial or irreparable injury. And number three, that it would clarify an issue of general importance in the administration of justice. So those seem very, very broad, and it seems like those could be applicable in a lot of circumstances. I can tell you that I have personally moved the court for, I want to say, 3 or 4 of these. I have had one granted, and so that is a better than average batting average. Although who knows if I get my next 5 denied as well, it will just be par for the course.
Hey,
So
Anthony,
yes,
in your experience, either personally or what you have seen, I guess, um, with the interlocutory appeals, is there a difference of percentage as to like, does the state win more of those or does the defense win more of those as compared to like the overall percentage of appeals?
yeah, that's a great question. I don't have the number at my fingertips, but I will say almost certainly that the state wins more of those appeals kind of because the definition is different. The state gets to do these interlocutory appeals as a matter of right. It's written into the statutes, whereas we have to ask permission. And the reason the state gets to do them as a matter of right is because if they lose a suppression motion, that may tank their entire case. Whereas if we lose a suppression motion, it's written into the statutes that we can even go so far as to enter a plea, and we still have not conceded the issue that we had raised. That we get to go ahead and appeal that anyway, notwithstanding that we're entering a plea. So the state definitely wins far more interlocutory appeals than the defense does, in part because theirs isn't really an interlocutory appeal, if that makes sense. Um, I think your question also sort of buttresses the point that I'd wanted to make about the broad criteria that is laid out in statute for granting interlocutory appeals. It seems to cover just about everything, but unfortunately, when it comes to criminal defendants, I think the court just doesn't take it seriously. In by court, I mean Court of Appeals. So obviously, you and I and Sarah and everybody that's going to be listening to this knows that for someone to go through a criminal trial is effectively subjecting them to a trauma that they're going to suffer from for a good long while. Aaron Nagy did a presentation here for the Dane County Criminal Defense Lawyers Association on how just trial work, just criminal practice, practicing as a lawyer, is trauma inducing. For an untrained person to be accused of something and have this threat of liberty, and many of our clients are incarcerated as they're awaiting trial, there can't be any credible denying that we're subjecting them to a very real trauma that will very likely have lasting effects. And again, I don't have these numbers at my fingertips, but I know that the effects of at least wrongful convictions have been fairly well studied, and that those negative effects are fairly pronounced. So I say all this to underscore the point that when it comes to that second criteria, that the court is inclined to grant interlocutory appeal in order to protect the petitioner from substantial or irreparable injury. They don't consider the fact that you're going to have to continue on with trial and that you might end up convicted by a jury who doesn't get to hear all the facts, just the facts that the judge says they get to hear. They don't consider that substantial or irreparable injury. And so again, this is an overview. I'm going to spend just a few more minutes on interlocutory appeals, but there is a significant amount of case law developed to the Court of Appeals saying, yeah, when we say this, we're not talking about just the run-of-the-mill average stuff that a defendant is going to be subjected to. And for what it's worth, I mean, just in terms of timeliness of this podcast, I know a lot of people will be watching it before the end of the month. It's January 14th as we're recording this, 2025. And just last week, the U.S. Supreme Court had denied President-elect Trump's motion for an interlocutory appeal, essentially for the reason I'm talking about right now. They said, yeah, well, it sucks, but it's a minimal sort of suckiness, and everything that you want to raise, that could be raised on what's called a direct appeal, which is what we're going to get to in just a moment. So the other thing I want to note, first, let me say, in terms of detailed mechanics, these are so rare that I do have to look it up every time I do it. And every time I do it, being once every 5 years or so, things will have changed in the meantime. You can, I think the first time I did it, I don't even know if e-filing was a thing at that point. And so I definitely had to have the AG serve personally, as well as the district attorney, because the statutes prescribe who's representing the state at what point. And during circuit court proceedings, it's the district attorney, and during appeals, it's the AG. And if the Court of Appeals accepts an interlocutory appeal, it's likely the AG you're going to be arguing against, unless they kick it back down to the district attorney, by which I mean they ask the district attorney or designate the district attorney to do that for you. So even though the nitty-gritty of it is beyond the scope of this presentation, I will say that two things. First, if you have it pop up, obviously we're not just going to write the interlocutory appeal for you, but feel free to reach out to me, and I can look up what I've got in the previous ones. I haven't. For that matter, so can Sarah Schmeiser, so can Cole Ruby, maybe even Christopher August at the Wisconsin State Public Defender, or if you call the Madison office of the State Public Defender. I think all of us are available to, at least give a little bit of guidance and advice in how to do these sorts of things, because we've all done them before, and some of us have had some luck. So broadly speaking, what happens is that your petition has one or all three of those criteria about protecting your client from substantial or irreparable injury, clarifying an issue of importance to the administration of justice, and materially, of course, material advancing or terminating the litigation. Like they're never going to accept a suppression issue, but if, for example, the court gets a suppression issue wrong, that would absolutely terminate litigation, right? So in addition to outlining those criteria about why this issue is important, your petition should also, if you want to win, contain your argument about why you should win. And the reason that's true is because in most instances, if the Court of Appeals is interested in your interlocutory appeal, it's hard to get them interested, but if they are interested, they will order the state to respond. And once the state responds, one would think that you would then go ahead with briefing, that you would have a brief in chief and a response and then a reply brief. But in fact, most often during interlocutory appeals, after the petition is made, the state will say, we're not going to respond to that unless you order us to. And the Court of Appeals, if they're interested, will say, yeah, actually, state, do go ahead and respond. And most of the time that settles it. With the two instances that I'm thinking in particular is the one single interlocutory appeal that I won. And I certainly didn't win on the grounds I wanted to, right? It was here in Dane County, and one of the, I had argued to the judge, I won't say who at this point because it was 10 years ago and a lot of water has gone under that bridge. But I had made the point to the judge that my client wanted to withdraw his plea, and one of the reasons that he'd entered his plea is because young black men get convicted disproportionately when they have trials in Dane County. And the judge had said, well, then maybe they should stop committing so many crimes. And I found that to be very offensive, and I structured my whole interlocutory appeal around it. And to be clear, this was a withdrawal of plea before sentencing. My young black client had been kicked out of the first offenders program for failure to take responsibility in a meaningful way, which wasn't as pronounced and italicized and underscored at the time as it is these days in Dane County when they're asking people to sign up for FOP. So I really leaned heavily on the racial aspect of that case because I found the judge's comments to be abhorrent. And the Court of Appeals was interested and they ordered the state to reply. And the state said just something so benign and innocuous in the course of their reply to me, but they had essentially conceded that in fact, the court should have held an evidentiary hearing. They made some sort of benign, innocuous comment like, oh, had an evidentiary hearing been held, likely the court would have found XYZ. And so the Court of Appeals said, you know, you just conceded that there should have been an evidentiary hearing. And so we are reversing the circuit court's decision that Anthony and his client don't get an evidentiary hearing, and we're remanding it for that. And at that point, I handed the case off to my friend Nick Gansner because my advice to my clients of whether or not taking responsibility was going to be an essential aspect of the first offenders program might have made me a witness in that case. I don't think I actually had to drop out, but it was just best practice. Speaking of, we might get to this a little bit more in a few minutes when we're talking about direct appeals, but it really is also best practice to not do the appeal of a case that you handled at the trial level. It is a waivable conflict. Your client can say, no, I believe you did everything right, and I absolutely want you to handle the appeal. But your client would need to know that they're giving up the possibility of alleging ineffective assistance of counsel. Obviously, I'm not in the best place to tell whether or not I screwed up during a trial. That would be better for some other lawyer to look at and examine because I'm going to be biased. And it might be biased in either direction, but it's for that reason that it is usually a bad idea for a lawyer to handle an appeal on a case where they've been involved at the circuit court level. That said, I have had clients that are just so damn frustrated with their trial attorney after they've gotten convicted that they have hired me to do the appeal and wanted me to do the sentencing as well. And I have done that. I think there's very, like, obviously a lawyer can screw up at sentencing. And I don't want to diminish that possibility, but it's a lot less likely that they're going to screw up handling just that one proceeding than otherwise. So the underlying point there is that yes, you can handle an appeal of a trial that you lost, and you're welcome to do so if your client waives that conflict. It is generally ill-advised. That also is a segue into a good point about ineffective assistance and appeals as of right. Let me just wrap up on the interlocutory appeal issue. Oh, the only other time, just as of recent memory, in terms of um, Court of Appeals effectively granting and then deciding an interlocutory appeal was a case where I was trial counsel, and the defendant had moved to review the judge's denial of bond on appeal because he was sitting there in prison, and his appellate counsel was none too pleased about that. And basically, while the Court of Appeals did order the state to respond in that case, they came back with a you lose because the record conclusively demonstrates that the judge exercised his discretion in um, in denying the motion for bond, even on the terms and the facts as counsel had presented them. So that's just to underscore that certainly the Court of Appeals could grant a petition and then say, okay, we're going to do this like we normally do and have a brief and a response brief and a reply brief and then a decision. But most often, what's important to know is that interlocutory appeals will most likely be decided just on the petition and the response at that point. So going on then to appeals as of right, what Sarah had pointed out is a very what sort of underscores the distinction between interlocutory appeals or paper only appeals and where most appeals of right start, which is to say with a motion for post-conviction relief. I'm going to go ahead and share my screen again. So what we're talking about in criminal cases in Wisconsin when we're talking about appeals is chapter 80930, and it's boring and it's unique and it's somewhat self-contained. It covers a lot of information about boring things like when transcripts have to be filed and when the court record has to be served. But the most important part of 80930 is that it says in Wisconsin, we start with what's called a motion for post-conviction relief. And the reason we do it is because oftentimes what we're alleging in an appeal will not have a basis that's already in the record. That is to say, if we're alleging ineffective assistance of counsel, for instance, not every strategic decision or failure to employ strategy is going to be evident from the transcript which is in front of us. So ineffective assistance of counsel is a really great example of an issue that the Court of Appeals has said just repeatedly ad nauseum in so many cases. We're simply not going to hear an appeal on this unless there has been an evidentiary hearing to develop the record, because we're not going to guess about counsel's actions or motivations or failures. There very well could have been a strategic reason for what they've done. And I suppose back in the day, there must have been many efforts from folks to try and say, oh, look, it's clear that counsel had screwed up. We don't really need an evidentiary hearing. And the Court of Appeals was having none of it. So unfortunately, what that means is where you start with an appeal is exactly at the court that convicted and sentenced your defendant, with a couple of rare exceptions. I believe, number one, It's always possible that between conviction and a post-conviction motion, a different judge will have been elected or appointed to the branch that you're in. And number two, Milwaukee has some weird rules. So I think that notwithstanding what circuit or branch you were convicted of in Milwaukee, it may all be channeled to a couple of courts that are assigned to deal with post conviction issues. It's also I don't practice a ton in Milwaukee. It is, and one of the reasons is Milwaukee's fairly well known for uh, denying post conviction motions without an evidentiary hearing much more than other counties are. So all this is to say that evidentiary hearings are required if your post conviction motion contains facts which, if true, would require relief. So if you put in your post conviction motion facts that would require relief if true, then you're entitled to an evidentiary hearing to figure out if those are actually the facts or not. And in those cases are well known in Wisconsin. It's Bentley, it's Allen. So that's where that standard comes from. Milwaukee is a big fan of saying, "Oh no, we're denying the post conviction motion because you haven't alleged facts, which, if true, would entitle you to hearing." And sometimes the Court of Appeals affirms them and says, "Yep, no, that's true. Like even those facts didn't work. You can't have just merely conclusory allegations. You need to show more." So that said, backing up just a little bit, there's also sort of a sensitive matter of strategy as to whether or not, like, you certainly have to bring all of your issues to the trial court first, but you may have already done that in the context of trial. And so there's a question then about whether you want to bring an issue again. There's a question of strategy as to whether you want to bring an issue again to a circuit court in a post conviction motion hearing. So, for example, say that you're saying two things. Number one, that trial counsel is ineffective. And number two, you still firmly believe, especially based on the way the trial went, based on some jury questions or what have you, that the court absolutely screwed up its suppression hearing. It's a suppression ruling that the evidence that you wanted suppressed should have been suppressed. So you can give the circuit court, the trial court, another kick at the cat by saying in your post conviction motion, hey, look, clearly the way trial went, you should have decided this differently. And the way trial panned out, the way the prosecutor argued it, proves the point. It shows what I told you it was going to, it was going to go the way I told you it was, and it did. Uh, Most often, I will tell you that the judges, whether it's a conscious sort of dishonesty or not, judges are most often inclined. They may be more inclined to overrule themselves than the Court of Appeals is, but they are generally disinclined to to overrule themselves when they're reconsidering an issue. One of the first appeals I brought, I thought, was very clear cut, where a judge here in Madison had considered some inappropriate factors when she was sentencing my client. And I brought it up to her because I thought it was going to be the quickest way to get relief. And instead, she used the post conviction hearing as an opportunity to buttress her record, saying, "No, Anthony, I clearly remember that your client had scoffed when the victim was speaking, and he rolled his eyes, and I was so taken aback by his attitude about that definitely had fed into the sentence that I imposed." That's not stuff that she said when she'd originally sentenced my client. So in that instance, it was an error for me to present that issue to her. Now, if she said, "Yeah, you're right, I was just angry because he was being a jerk and I shouldn't have," that would have been a quick win. But now that I've got a little bit more time under my belt, I realize that's probably not something that most judges are going to be inclined to admit, even if it is true. So, all that is to say that you don't have to put issues that a circuit court has already decided in your post-conviction motion. It's really common to leave out suppression issues because those are already decided. Uh, some of these will be sort of on the fence issues, and there can be good arguments made for both of them, both from a legal perspective and from a strategic perspective, like whether or not a court had considered an improper factor in sentencing. I think that's something that it would be fair to go right to the Court of Appeals with, and it's also something that I suspect prosecutors will say, well, they didn't raise that issue in the court below. So, each of these is going to have, each of these issues is going to have different case law behind it in terms of to what extent it has to be raised before the circuit court. But certainly make no mistake that the circuit court gets the first kick at the cat as to every issue, whether it's sentencing, suppression. We don't just pop up with new issues at the Court of Appeals. At least we don't do it and win. So we'll sometimes get, on the other hand, we'll sometimes get some hyper technical pushback from prosecutors like, oh, we didn't offer an affidavit in support of our client's contentions that he only pled guilty because his lawyer pressured him. There's no harm in offering an affidavit, especially if you're trying to not have your client testify at a post-conviction motion hearing. Although, again, as a practice note, I've both had clients testify and I've had them not testify at post-conviction motion hearings, both when they've testified at trial and when they have not. And I will tell you, it's odd for me as an appellate lawyer, but prosecutors are usually really reserved with their questioning of a defendant who's already been convicted. You'd think that they would really get into the nitty gritty of, yeah, but did you do this? And in the few times that I put my client on the stand, even when they haven't testified at trial, the prosecutors haven't done that. No, they've gotten certainly sometimes pushy with the topic at hand, like, did you really tell your lawyer that? Why would your lawyer say this, etc. But they surprisingly, in my experience, haven't dove much into the facts of the underlying case. So prosecutors will sometimes say, look, this guy shouldn't get an evidentiary hearing because he didn't offer an affidavit that says that his client is swearing that his no good dirty lawyer told him, like, pressured him to enter the plea. I don't have the site immediately available, but the Court of Appeals has said, look, as long as we're asserting it in our motion, our post-conviction motion, that's enough. We don't need an affidavit attending it. Again, if you don't want your client to testify, do the affidavit, right? Because then you're going to have their sworn statement in the record, and the prosecutor can't cross-examine an affidavit. But if you don't have an affidavit and your client wants to testify, certainly there's not a requirement that there needs to be an affidavit just to appeal, even though some prosecutors have that belief. So just to contextualize things, I want to say we've got about 15 to 20 minutes left. I'm going to wrap up the direct appeal thing here. We'll talk a little bit about appealing to the state Supreme Court and then the various ways of appealing to federal courts. But one of the things I want to note on the direct appeal here is, in terms of arguing to the circuit court and submitting all the issues, it's not always true, but a good rule of thumb is that the greatest chance for success is at the earliest stage of proceedings, right? And I think that we all know that practically. I mean, we are much more likely, I think, able to resolve a case with a prosecutor in an agreeable way than we are to somehow end up with a joint recommendation on a sentence after a trial, right? And so likewise here, we're more likely to get a favorable decision on a post-conviction motion than we are to get a reversal from the Court of Appeals, or even to get the Supreme Court to take the case. A couple other notes about appeals as of right. There's almost, excepting Milwaukee, which might just deny the post-conviction motion, there's almost always oral argument, and supplemental briefing is very common. It's actually really common to have several evidentiary proceedings. So while a post-conviction motion is supposed to be decided within 60 days of it having been submitted, oftentimes we have to make repeated motions for extension of time in order to give the court and us time to have more continued evidentiary hearings, and then give the court some time to make a decision. It can really drag out. It doesn't. It's disheartening, but it doesn't surprise me when it literally drags out for more than a year. After all of that, with a post-conviction motion, a decision from the bench is most common. It can be written. Really depends on the judge's style. It is much easier for them to make us come to the courthouse in order to hear their ruling than it is for them to type and add citations and whatnot, and have the court reporters just take down what they said. So with that, though, written decisions are helpful. If you can get one, that's often favorable, because if you're trying to make the point that the circuit court didn't do a very good job in issuing its decision, a poorly written ruling on your post-conviction motion will do a lot more than your characterization of what the judge said in the bench. So in terms of the Court of Appeals, then, supposing you don't win your post-conviction motion, you file a notice of appeal and all sorts of boring stuff that's covered in chapter 809-30, the statement on the transcript. Don't forget to pay your filing fees, both to the circuit court and the Court of Appeals. They will certainly ding you on that. And then after you get through all of that drudgery, have the transcripts produced and make sure that they're available to opposing counsel. Then you write a brief, and the state writes a response brief, and you write a reply. And then the Court of Appeals takes just as long as they want to issue a decision. So, in the context of those briefs, I think we all learned how to do it in law school. You lay out the facts, the issues, the argument. Obviously, it's good to be as clinical and as objective as possible in laying out the facts favorably, but as advocates, it can be hard to do that fairly. I would say if you're writing, whether it's a brief or a petition for an interlocutory appeal, you're going to gain a lot of credit with the courts just by being, meticulously objective, if you can, in the fact session, and saving your argument for argument. So the thing that I would stress there, though, is understanding the standard of review. Just like we all know that the standard at trial is, that the state has the burden to prove whether or not someone is guilty beyond a reasonable doubt to a unanimous jury. There's different standards of review for the Court of Appeals. There's de novo, mixed, and then the abuse of discretion, clearly erroneous. De novo simply means that they're looking at the law fresh without any deference to the court below. The mixed is they're going to accept the facts as found by the circuit court unless they're clearly erroneous, and they're going to apply the law on their own without any deference. And then the abuse of discretion, clearly erroneous, is basically, did the judge say the right law and apply the appropriate standards? It's very much not, hey, what would we have ruled, but did the circuit court go through a process of reasoning that resulted in a rational decision? So it's important to include that in your briefs. And there's I think that we've all done analogous stuff in our motions to the circuit court. So supposing we lose at the Court of Appeals, we then appeal to the state Supreme Court. And in Wisconsin, there are several criteria for granting review. It's important to say that, of course, review is not automatic, that it is discretionary. And so they will underscore that they are not an error correcting court, that what they're looking for are either issues that are going to help them develop the law, and that the issue is novel and going to have a statewide impact, or that the Court of Appeals decision is in conflict with controlling opinions of the Supreme Court. And those are all, so the criteria for appealing to the Wisconsin Supreme Court are all laid out in the statute, and that will be appended to the materials as well. So among the criteria are real and significant questions of federal or state constitutional law, the development and clarification of law. And when you're writing these, you don't have to pick just one. You can incorporate as many as you'd like, and it doesn't even have to fit these criteria. These are just saying, they're just saying like, these are the criteria that have a really good chance of getting us to accept review. So here's the tricky thing about petitions for review to the Wisconsin Supreme Court is that once your foot is in the door, the focus shifts from it being a novel question of importance to the state that has never been answered before to you saying, this issue has clearly been decided by precedent, and of course you need to decide in our favor. They're used to that. They know that's how that goes, and you're not going to lose any points for it. All that said, it's important to absolutely include the answer to your question, include the argument and the answer to your question in a very sort of brief way in your petition for review. But at the same time, the petition for review is meant to get their interest and get them to accept the case, after which they will require thorough briefing. Unlike the Court of Appeals, where there is almost never oral argument, with the Wisconsin Supreme Court, there is almost always argument. I can't think of an instance in which there wasn't. So maybe it's not almost, maybe it's just always. And so, yeah, you'll have a thorough chance to present your case in the brief and in the reply after the state responds. And then if the court has any questions, you have an opportunity to address that at oral argument. So even if you lose there, that is not the end of the road. We got about 5 minutes left. So I'm just really briefly going to address remedies through federal courts. And the first one, I would say, although the chances are very low, I think the Supreme Court, the US Supreme Court, accepts something like 150 out of the 7,000 petitions that it gets each year. Even though the chances are very low, I would say if you think you've got a federal issue, don't save that for habeas review. Just go ahead and file a petition with the US Supreme Court right away. Now, it is very costly. Aside from your time, which I'm sure you should be charging a lot of money for, there's also very particular brief formats and printing expenses that go along with it, to the tune of like, $5,000. So once, and again, the U.S. Supreme Court has its own criteria. What they're looking for is that either a state court of last resort, like the Wisconsin Supreme Court, or that federal circuits have disagreed with each other, or they've disagreed with clearly established federal law, clearly established constitutional law. Even if they've done that, the court is still unlikely to take the case, unfortunately. I mean, you can point to inter-circuit splits and intra-circuit splits where they clearly haven't applied U.S. Supreme Court precedent, and they simply won't take it because it's just not on their agenda for, like, I don't know, this decade. That said, you have a much better chance of winning your case if they do accept it. You have a much better chance of winning your case on direct review to the US Supreme Court than you would be if you wait for your case to wind through the lower federal courts on habeas relief. So in habeas relief, you can say, well, a constitutional right of my client was denied when the court wrongly found that his counsel was not ineffective. I mean, that would implicate, the Fifth and Sixth Amendments, and that would be clearly a constitutional issue. And so the first step in a habeas case is to bring that constitutional issue within just a year after your time for direct appeal has ended. You bring it to the district court, the Eastern or Western District of Wisconsin, and at that point, you can only argue the constitutional stuff, and it's got to be constitutional law as clearly announced by the U.S. Supreme Court. So we're just about out of time. What I'm going to wrap up by saying is the standard for habeas relief is whether or not the state courts unreasonably found facts or unreasonably applied federal law. And that is a very different question than the Supreme Court could address on direct review, which doesn't entail that kind of deference. So it is to say, every time you lose in federal court, it sort of gets worse. Like the district court says, well, the Court of Appeals wasn't unreasonable. We wouldn't have decided that, but they weren't unreasonable. Then you apply to the Seventh Circuit, and they're like, well, we wouldn't have decided that, but yeah, it's not unreasonable. There's very little chance on a habeas case that by the time you get to the U.S. Supreme Court, they're going to say, well, everyone beneath us was really stupid, and they were absolutely unreasonable. I mean, at that point, they're literally calling 5 different courts below them morons for being unreasonable. So there's obviously a lot more detail. I will put some more detail in the course materials. That is a very broad outline of appellate process. I know that we were sort of front end heavy in terms of interlocutory appeals and appeals as a matter of right. For what it's worth, that's somewhat intentional because for most of you, if you're going to be doing a lot of criminal appeals, you'd already know the stuff that comes later on in the process. So for trial practitioners, I think that this is that the front end loaded information is probably the best to focus on. And again, if you have questions, certainly you can reach out to me. It is anthony@criminallawyers.esq. Sarah Schmeiser, who's at Stroud. Christopher August, he might be a little bit upset that I told everyone they should call him. But if you want to bug people otherwise as well, you could call the State Public Defender Madison Appellate Office. They're the ones that handle appeals for most of the state of Wisconsin. So,
can I ask a final question?
Of course.
So what I often most need to tell my clients, or what clients have questions about, is about the time period, how long before something has to be done to start an appellate process. Is that something that you can quickly just run through in terms of some of these what you can tell clients in terms of how long they have to get going on this?
Yeah, that's another really great question, and it is very different from the civil world. So the technical answer is that as we tell them at sentencing, if you don't tell your trial attorney within 20 days, you lose your right to appeal forever, because they would have to file a notice of intent to appeal. And that starts the process to sort of like put the court on notice, like, oh, he's going to get an appellate lawyer and we need to compile a record and all that sort of thing. So once the statutes say that once someone is convicted, there's 20 days for them to file a notice of intent to pursue post-conviction relief. And I know that on the record, as a matter of course, in Wisconsin, we tell them if you don't do that, you lose your right to appeal forever. Practically speaking, that's not actually true. You can go months beyond that, if not a year. I believe the latest I've personally done it is a year when a client has just said, I want to appeal this. I just haven't had the time. I haven't had the money. And so we were able to resurrect their direct appeal at that point by extending the time for filing that after the fact. Unlike a civil case, that does not deprive the court of jurisdiction, because in criminal cases, the court can extend the time for various filings, including the right to the notice of intent to seek post conviction relief. All the same, it's not good to screw around with. Like if as trial attorneys we're obligated to file that if our client tells us to, and certainly it's a simple form. Delaying doesn't doesn't really help anybody. So the other aspect of that. Sorry, go
Anthony,
ahead.
just
Yep.
real quick, because you made the point about the difference between criminal and civil, and since in Wisconsin that first offense OWI is civil, would it be the case that you really, really do have to pay attention to the timing on a first offense OWI?
Well, yeah, and maybe that's what Sarah was getting at. That's absolutely true, for sure. You would not want to dilly dally, because on a first offense OWI, I mean, especially, I don't know so much about the Court of Appeals, but the Wisconsin Supreme Court has a record of just absolutely, uh, as Sarah often says, there's the OWI exception to the Constitution. Um, so they will deny in a civil case at every chance they can. And frankly, with the civil rules governing, they might not even have the authority. I don't know this off the top of my head, but they might not even have the authority to extend the time for filing a notice of appeal. So it would be absolutely important on a first offense OWI to get that done. For criminal matters, I mean, there's really no reason to screw around, but with liberty interests at stake, the courts have demonstrated much more of an inclination to extend those times. After a notice of intent to file post conviction relief is filed, there is a um, set of actions that court reporters and clerks of court and you have to take that are all laid out in 80930. But eventually it says that once the last of transcripts or a court record is received, an appellate lawyer, a post conviction lawyer, has 60 days to file a post conviction motion with the trial court. I will say that nobody checks the date on those, practically speaking. I've never seen a case denied because it was at least a little bit outside that time frame. I've never seen a case denied because of the time frame on a supposedly direct appeal. All the same, it's the best not to screw around with. There's very little to be lost by filing a motion with the Court of Appeals saying, "Hey, extend my time for another 60 days because it's a big record and I just have a workload." And I will tell you that the Court of Appeals routinely grants like the first three extensions for free. Like you barely need a reason. And that way you're not screwing around. The Court of Appeals has said that dismissal of a case with prejudice is a fairly extreme sanction, and they're loath to do it. There was the case Kalal is most often cited for interpreting statutes to mean what they say. There was another case where the Court of Appeals had dismissed one of that attorney's cases as a sanction against him for asking for too many extensions. And the Wisconsin Supreme Court said, look, we don't approve of all that, but you don't get to just dismiss his case because his lawyer was late. And that's the way it is with criminal stuff. Civil stuff, different story, but really great questions. With that, I think it's a wrap unless any other questions before we go. No? Cool beans. Well, thanks to you guys for attending this live. I will go ahead and get it to Barry so he can share it with everyone. And to everybody watching, if you do have questions, comments, concerns, again, I believe it'll be in Barry's email what my contact information is. But absolutely feel free to reach out to me, Anthony at criminallawyers.esq. And thanks so much for attending. I appreciate it.